Good morning, everyone. I would like to call this meeting to order and would ask everyone to silence their cell phone if they could. Okay, at this time, I would ask Don Conkle if he would lead us in the Pledge of Allegiance. To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, good morning. I'm Representative Steve Barrar, Majority Chairman of the House Veteran Affairs Committee and Emergency Preparedness Committee, and I want to welcome everyone to our public hearing today on the subject of House Bill 2522, sponsored by Representative Ferry. Due to time constraints, I want to let our prime sponsor cover the purpose of the bill, and it's our intention to conclude today's proceedings by no later than 11:30. We will go into session. We will start session about 11 o'clock, but I understand there aren't going to be any votes taken until later. Okay, Chairman Sonato, do you have any opening remarks?
Thank you, Chairman Barrar. I just want to echo what you said. We look forward to hearing the testimony today, and let's just get her done.
Thank you. I'd ask the staff and the members that are here to introduce themselves. When we start down here.
Representative Frank Ryan, Lebanon County, 101st District.
Rick O'Leary, Executive Director for Chairman Barrar.
Representative Frank Ferry, Bucks County.
Mike Hillman, Democratic Executive Director.
State Rep Martina White, Philadelphia.
Representative Anita Kulik, Allegheny County.
Barry Joswiak, Berks County. Brian Barbin, Cambrian, Somerset County.
Great, thank you. At this time, I call up Subcommittee Chairman Frank Ferry, who is the prime sponsor of House Bill 2522. I applaud you for your work on this legislation, which is very important for our volunteer firefighting community and local governments they serve and protect. Chairman Ferry, you can begin.
Thank you, Chairman, and thank you to you and the staff for putting this hearing together. We have a very good mix of presenters today, ranging from the department, the emergency services, and obviously the local governments and individuals that manage the trusts. We all know the impetus of this, and that's Act 46. The Senate previously held a hearing on this issue, or I should say it's a result of Act 46. The Senate previously held a hearing on this issue, I believe it was last year. And we all know we need to find a solution for the workman's comp coverage for our volunteer fire companies. The legislation is a first bite at that. Obviously, we'll need to hopefully whittle that down to what we really need to get this successful next session. The SR6 Commission, whose report will be coming out the end of November, I know this is one of their important priorities to get resolved. So I know we're on tight time constraints. Without further ado, I say we bring the first panelist up.
Great, thank you. At this time, let's see, our panel will consist of Mike Vovakis. Did I say that right?
Vovakis.
What is it?
Vovakis.
Vovakis, okay, sorry. Deputy Secretary for Compensation and Insurance, Mr. Andrew Thomas, Director of the State Workers' Compensation Insurance Fund, representing the Pennsylvania Department of Labor and Insurance. It's a pleasure to have you both here with us today, and you can begin your testimony when you're ready.
Chairman Barrar, Chairman Santaro, thank you very much for having us. I particularly want to thank Representative Ferry for his very diligent and thoughtful engagement in this important endeavor. Representative Ferry's been, we've had many conversations. We are going to have many more as this proceeds, and we look forward to that. And we are happy to offer our assistance and expertise however we can. I've thought back on the several hearings I've done regarding volunteer firefighters, and we've submitted fairly lengthy testimony with all sorts of technical, legal issues that we're going to all be discussing as time moves forward. But as I thought about what I could do better, I think what I want to take a second to do is explain insurance and what SWIF is. It occurred to me that evidence has indicated, and discussions I've had indicate that there's sometimes a confusion about what the State Workers Insurance Fund is, and SWIF is an insurance company. It is a statutorily created entity that is supposed to be providing insurance for businesses and entities who cannot receive insurance in the open market because the commercial carriers don't want to carry them. So SWIFT is the fallback for any business or entity that can't buy insurance otherwise, workers' comp insurance specifically. It's not funded by the general operating budget of the Commonwealth. It is not Social Security. It's not disability benefits. It's paid for solely by premiums from our policyholders as well as investment returns that we earn. So it's to oversimplify things a little bit. Insurance is considered as a shared risk of many for the benefit of a few, right? So we're pooling a whole lot of policyholders to benefit the few who may have a significant need, who may have a cost that is untenable to them, and that risk is spread out amongst multiple policyholders. And while the underpinning of the Pennsylvania workers' compensation is humanitarian, unquestionably, it's not a social service. It is paid for by policyholders. And let me just give you a couple of quick examples. Unfortunately, a few weeks ago, there was a hearing. I couldn't testify. I was out of town. And my read of the testimony was that there was some dissatisfaction with one of our policyholders, Volunteer Fire Company, because they didn't feel, they felt that their premiums were outpacing what they're used to paying as well as outpacing the benefits they receive. And I understand that. Their policy premium did increase significantly when they left a particular municipal trust to come to SWIFT. In 2016, they had some unfortunate situations where several firefighters were injured. There were, I believe, 6 claims. 2 of them were significant. So from 2013 to 2016, if we add up all of the funding that SWIFT paid out, SWIFT paid out almost $180,000 in claims, and for those concurrent years, we collected $120,000 in premium. So I understand that there is some dissatisfaction with SWIFT's premiums, but there are also, SWIFT is also serving its purpose as the insurer of last resort in covering these injuries. Another more tragic example that really is, I think, illustrative of the bigger problem that we're all going to be discussing is the tragic case of a young firefighter who in 2013 was responding to a fire when he veered off the road and struck a tree. Sadly, this young person is now in a wheelchair, barring any miracles in medical science. He's going to be in a wheelchair for the remainder of his life, which is actuarially calculated to be about 53 years. That volunteer fire company has paid about, at that point, about $22,000 in premiums, and so far, SWIFT has paid $1.6 million out on that claim. We expect for the lifetime of this individual that this claim will cost us upwards of $3.2 million. So I just wanted to lay out a bigger picture of what SWIFT does. And I understand the politics are local, and I understand the concern that our General Assembly and the folks in this committee have for their local tax dollars, and absolutely respect that. But we could not support these sorts of claims without the body of policyholders that we have. There are no big secrets to calculating premiums in the workers' compensation world. We do it the same as every other insurance company that writes workers' compensation. So I'm not going to explain that. I'm happy to explain it if you have any questions about why SWIFT is priced the way it is or what goes into the calculation. And as I've illustrated, the SWIFT reserves are not isolated to a particular policyholder. The risk is to be spread and is intended to be spread amongst all policyholders. As a point of reference, well over 95% of all volunteer firefighter claims that come into SWIFT are paid. I think the number is closer to 98.5%. So, the concern that SWIFT is not doing its job by not supporting our policyholders and their claimants is really difficult to understand. And I will tell you that our first report acceptance is 75% for volunteer fire companies. For the rest of our policyholder body, it's more like 65%. So we're accepting some more volunteer fire companies at the beginning, and that's not a policy decision. That is simply we get more of the information that we need to make the decisions that we have to make from volunteer firefighters up front.
Yeah, and that's a good point. The ones that are initially denied, it's usually because we don't have all of the information that we need yet. Once we get that information, that's what results in the ultimate of about 98% of them being accepted.
Yeah, SWIFT is statutorily required to make a determination one way or the other in 21 days. So we're on a timeline to get this information and be able to assess it. Once we make that, if we wait till after 21 days, we own the claim. You can look at it and say, well, you're accepting 98.5% of them anyways. What's another 1.5? Well, that 1.5 is really the fairness to all of our other policyholders. I noticed that the Delaware Valley Municipal Trust is on the agenda. We've had some conversations with them, and we are certainly happy to continue those conversations when the time's appropriate for them. So, Chairman, I'm happy to answer any questions that you have.
Okay. Any members have questions? You want to ask it? Let me ask you a question about mental health injuries, like traumatic brain injuries and post-traumatic stress. Is any of that covered by workers' comp?
Yes.
Which,
just like it is for any other workers'
so
comp.
if I have a traumatic brain injury, then it's not a problem getting covered for that then? Okay. How about post-traumatic stress?
This should be covered just like any other workers' compensation policy, whether you're a firefighter, police officer, or representative in the House of...
That has been a complaint about, or at least I've heard that post-traumatic stress injury is not currently covered under workers' comp benefits. And actually, we have a bill to look at that.
It's covered.
Okay.
I mean, if it's, again, each of these claims is looked at individually. So, we do an examination of the medical records. Our claims folks do an examination of the medical records. They look at the event. They gather their information. And unless there is a reason to not claim it, or not own the claim, we own the claim.
Okay. Frank?
Yeah, just a couple of things. Thank you, gentlemen. Appreciate you being here, and I appreciate the time you've spent on this before with our conference calls and the like. And I don't think, I know the fire service is upset about their premiums. I think my department just paid theirs, and it was $42,000, which is obviously a very substantial premium. But I understand the situation you're in, because you didn't have any reserves built up for us. All of a sudden you have 1,000 volunteer fire departments where their number is dropped in your lap with no reserves built up, and the looming threat of Act 46 and whatever the ramifications are going to be with that. And I know it's not your purview, but I don't know if anybody else from the department's here. I wonder if we can get a copy of the latest annual report from the department on the cancer claims under Act 46.
Sure.
There was an annual report that was statutorily provided, and that goes to the Labor Committee. It doesn't come to us. But as I was talking to the chairman before this, we haven't seen that, but I don't think the volunteer claims were anywhere near as significant as some in the industry thought they would be. A couple questions. Subrogation. You guys obviously subrogate against the responsible party. Let's say somebody had an at-fault accident with one of the volunteer firefighters. Obviously, you guys pursue the subrogation, correct?
Yes.
Okay, good. I just want the committee to know that, because we'll take my case in particular, since I am one of the 400 and some claims you've had so far. There was somebody that ran a stop sign in front of me while I was responding to a call, and that person was found at fault. They were actually cited by the state police, pled guilty to the charge. So I just think it's important when somebody else is at fault and it results in that volunteer firefighter's injury that the department's pursuing subrogation, which I know in my case you did. And it's important to offset the costs that you incurred for somebody at fault that wasn't the volunteer. With you guys being the insurer of last resort, I guess, unfortunately, with what happened with Act 46 was we became kind of an uninsurable industry, and you ended up with all of us. But I think the majority of the fire companies have pretty good loss runs with you guys, correct? The ones you're insuring, there's been...
I'm sorry, have what?
Have pretty good loss runs. Like, there's not a lot of claims, or there's very few claims, or maybe a broken ankle or something relatively basic. Is that accurate?
Broken wrists.
Yeah, broken wrist. Thank you. Hey, this one right here.
Yeah. I mean, I have some examples I just printed out because they're local and I'm familiar with them a little bit. One municipality prior to coming to SWIFT, was paying a premium of $39,000 a year, and then after SWIFT, their premium went down and then fluctuated up to 41 and then down to 35. And their loss runs, their claims were minimal. The example I gave earlier of the fire company that was that their premium went from $16,000 with a trust to almost $41,000. So there is a wide range of changes that happened in that premium. But many of these volunteer firefighters are really pillars of what ought to be done for safety and in a workplace.
Right. Just two other points. There's also the ambiguity of coverage. I know there's a bill out there, I think it's about the fire police being covered. During our conference call, I think one of the conference calls, we talked briefly about other members being covered. And that's something that if we stay with SWIFT, we, the Volunteer Fire Service, we're going to have to get straightened out, because I will tell you, my volunteer department couldn't survive without what's called our contributing member, our non-first responders coming in. Like, for example, we have people that staff fire prevention tables that have never ridden on a fire truck and don't intend on ever riding on a fire truck. But if they're not staffing the fire prevention table, especially during this month where we have a community event every few days, if they're not doing it, the volunteer firefighters have to do it. Our numbers are dwindling. Our treasurer, who's an accountant, never wants to set foot on a fire truck, but he does our bookkeeping and pays our bills. And, so the contributing members, the fire police, and obviously the men and women that are getting on the fire trucks, we all need to have them covered. Don's going to be testifying later, but in terms of ratings and things of that nature, that's something that we need to look at as a whole down the road. And I'm not blaming you guys for that. I'm just saying whoever's providing coverage to the fire service, because we need to classify the individuals that are actually responding to the fire calls, because they're obviously at the most risk for injury or a significant injury. And they're obviously the ones covered by Act 46. So that's just overall an issue that we have to address as we move forward with covering the fire service. And then also, just the way the rating's set based on population. I know there's some thought in the fire service, and again, it's not your fault. It was pre-existing, that perhaps some of the population is being double counted. If there's 3 fire departments in a particular town, the town has 20,000 people. If they're not clarifying who's covering what area, that we're all, that the town's chopped up. Sure, jump in. Yeah.
Because we have had some success already, and it's still something that's out there.
Right.
And if you look at it, we actually have currently 1,057 policies for volunteer fire companies, but on those 1,057 policies, we cover over 1,600 volunteer fire companies. Because something we put out years ago was the opportunity for volunteer fire companies to come together. So if there are volunteer fire companies that are serving the same population, they can come together and get one policy that covers them all, so that we're not doing that duplicate payments. So if that's still going on out there, I would highly encourage them to look for opportunities to do that.
Yeah, and we need to get that word out there. So I'm not blaming you guys for that, because I know you'll work with us on that, but that's just another issue that's affecting premiums, because there may be some populations being double counted.
Yep.
So that's all I have, Chairman.
Thank you. Chairman Sonato, did you have a question? Okay. Okay. Let me just announce that we've been joined by Representative Gillen, Representative Greiner, Representative O'Neill, Representative Mako, Representative Hill Evans, and Representative Dare. And our next questioner is Representative Greiner.
Thank you, Mr. Chairman. Thank you for being here this morning. Just on background, kind of interesting, I'm a CPA, also been a volunteer firefighter for many years, and a life member, not as active as Representative Farry now in the fire company, but nonetheless, a lot of people come to me with these questions in Lancaster County. And one thing, I have a few questions. First one, this is kind of with the CPA background, are the operating results of SWIFT, are they publicly available? Am I able to look at the financial statements or get an opportunity to see them? And I don't know whether they're online or whether I can get a hard copy or...
We can send you a link, or we can send you a soft copy, or you can print out all several hundred pages of it.
If possible, could I get a link to those if possible? That would be very helpful. Or maybe you could send it to the chairman, and maybe they can distribute them to the committee. Because I think in this grand discussion, I think it's going to be important for us to see that. Also, too, we were talking a bit. Representative Farry was talking a little bit about loss ratios or fire companies and what have you. Do you happen to have the combined ratio in the last few years? As far as that goes, and then do you have it broken out with just the fire company portion that SWIFT's covering?
I don't have it broken out by fire company. I don't have it broken out by fire company. Yeah, we can get you. We can break it out. We can break out the fire company loss ratio.
Yeah, like I said, this is a great topic. I think it's timely because I know a lot of fire companies. As we look at this, and there's going to be a lot of questions. This isn't going to be real simple necessarily to get through this. And then, of course, I know a lot of this was spurred on by the cancer. Through the bill that was actually before I was here that passed. And I was wondering, how long does it take for cancer claims to mature? How do you know? How do you get a true valuation of that as we move forward? I mean,
well, the interesting thing about the cancer presumption, and clearly, as Representative Farry mentioned, it was really the reason that municipal trusts and private insurers fled the volunteer firefighting company market. How they mature is curious, because what the statute does is give firefighters 600 weeks after their last date of service to claim a cancer presumption. So, really, I think that's going to be the stickiest point of all of this, is trying to figure out how to provide some visibility on that risk, because right now we have none. I mean, we still have, folks volunteering and fighting fires today that are relatively young, like Representative Farry, who are going to be, likely engaged in this for, 20, 30 years more. And even after that 30-year period, they have 600 months, 11 years, 11 and a half years to make a claim. So I don't have a good answer for that, sir.
Okay. Well, with all due respect, if Representative Farry decides to do this for 20 or 30 more years, I think he needs to have his head examined. That's all right. Actually, it's great what he does, but the whole volunteer firefighting has changed in the last 25 years too, no question. One last question. I know my understanding is in my area, the municipality pays for the premiums. Do fire companies pay the premiums directly? Is it a combination of both, or how does that work?
Some municipalities pay it, some fire companies pay it. It's really dependent upon what the locality would like to do.
Okay. Like I said, I appreciate your time. Like I said, this is an important subject, and I want to thank the chairman for the time.
Great. Any other of the members have a question? Anyone? I can't see everybody, so yell if you do. Okay, gentlemen, thank you for your testimony today.
Thank you.
Our next panel is Mr. Don Conkle, Executive Director for the Pennsylvania Fire and Emergency Service Institute. Don, it's great to have you here. First, I have to ask you, before you start your testimony, I've heard a very horrible rumor, something about you might retire.
I hope that's true.
Okay.
And we have interviews to do at the end of this month. 3 of the candidates can start January 1st, and 1 can't start to July. So if the 4th candidate's chosen, you'll have my smiling face, seldom smiling, but you'll have my face, for another 6 months.
Actually, Chairman Senato, have a resolution that we're sending to the governor that will prevent your retirement, if you're okay with that. So, right, Chairman? So, thank you. But your years of service, I'll tell you what, you've been a pillar around here, someone I've always looked to for advice as we do these issues, and I can't thank you enough for all the service that you've given the Commonwealth of Pennsylvania.
Well, we appreciate the relationship with you and obviously with staff and everybody else, so thank you for your comments. And, you know, I'm generally pretty good about keeping you on schedule or getting you on schedule, and I'll do that again for you today. I think, and you have my testimony, I think as I travel around the state, one of the top 5 issues, and it's only been the last 3 or 4 years, is the workers' comp situation and SWIFT. And while the majority of premiums are paid by municipalities, there's concern in the fire service about the cost of the insurance, and there's factors there that we might not be able to directly control. But in some circumstances, municipalities have actually reduced their annual contribution to a fire department to reflect the increase in premiums. And that's had some operational issues. But perhaps more importantly, as we look at trying to incentivize volunteers, we hear all the time about the difficulty in dealing with SWIFT. The perception is, and perception is 90% of anything, the perception is SWIFT is generally unfriendly towards claims. They believe that they demand a huge amount of paperwork, and at the Senate hearing last year, we had 2 volunteer fire chiefs come in with a box, a cardboard box, literally filled with the documentation provided to support 1 workers' comp claim. Fortunately, both of those departments had career staff, and otherwise an all-volunteer department, that could assemble that information and get it done. And a lot of volunteer departments, when you give them a request for 30 or 40 documents that they have to research and find, it simply dies because they don't administratively have the capability to do that. And that leads to the perception is if I get hurt here, I'm not protected. And when you begin to assess why are you going to spend 20 hours a month of your time volunteering to serve your community at no compensation, with the possibility of getting injured and not being protected, it's one more reason not to be a volunteer firefighter, and those numbers continue to decline. Secondly, the SWIFT determination, and it was not this way prior to SWIFT, that non-responding members, non-operational members of fire departments are not eligible for workers' comp, was brand new to almost everybody. And we've spent the better part of 15 years convincing volunteer fire companies that in the situation in Representative Ferry case, finding the accountant to be your treasurer, to find somebody that's an IT professional to be able to build you a website is critical, and save the people's time who are responding for training and response. Now that that's happened, I know several volunteer fire companies that have discontinued fundraising because they believe the people working bingo are not protected if they drop a chair on their foot or a table taking it down. And that's had a detrimental effect. And once again, as we look at reasons to volunteer, people throw up their hands and say there isn't anybody out here on our side. More and more is expected of us, and we get less, not more, in recognition of what we're doing. So people continue to drift away. Once you find somebody that's once you have somebody that's been working bingo for the last 15 years on a Wednesday evening, and it's sort of ingrained in their life to do that, and you tell them to go away till the problem's solved, when you call them back in a year and say, geez, guess what? We'd love to have you come back on bingo, you know, they discover, geez, there's TV shows on Wednesday night, or the movies are open, or whatever. They're less likely to be able to recruit them again to volunteer. So, I mean, those are situations that we hear regularly from the volunteer fire service going forward, and they need to be resolved. I think Representative Sperry's got a lot of work on getting this down. You know, when we first started talking about this 3 years ago, you know, forming an insurance trust is a lot more complicated than I think anybody realized. But I think if the fire service had confidence that whatever the organization was clearly had their back. You know, are there frivolous claims from time to time? I imagine so, as in anything. But most people, when they, you know, I had a guy call me 6 months ago who fell off a ladder at a fire scene and had the claim denied, broken arm, okay? And perhaps there wasn't adequate paperwork when they submitted the claim or whatever. But what that says to the members of that volunteer fire company is nobody's looking out for us. And they tend to walk away. And, you know, with that, I'll be available for questions.
So most of the situations that you're explaining just happened from when you went from the private pay coverage to SWIFT?
Yes. Certainly there was never a question, and I've asked for the information twice, and the volunteer fire service isn't always real quick on getting you information that you ask for, on people who had claims that, particularly on the non-operational side, on the fundraisers and the treasurers and people like that, that had been covered in the past and are no longer covered, and everybody told me they could get us that information. I've called about 3 times. Oh, no, it's in a box that's filed away. You know, when we have time, we'll get to it. So I haven't been able to bring you in the documentation, but I hear that story frequently, that this was never a problem. And there's new interpretation of the law. You know, I'm not an attorney, played one at Station 8 for years. But, you know, we've had people say they think the interpretation of the law is incorrect, but that's not for me to say, other than I know that interpretation has had a detrimental effect. And I don't think the claims are huge. I mean, you're unlikely to find the catastrophic injury to somebody working bingo or being the treasurer that you are somebody that's actively responding to a fire.
Questions from the members? Anyone? Back here? Representative Barbin.
Thank you, Don. This has been a long-going issue for the volunteer fire company. Is there any state that has set up SELP funds like it's anticipated under this bill?
I have not looked, and to my knowledge, I'm not aware of any. Okay. Certainly the contiguous states to Pennsylvania have not. But I think this is a relatively new issue. Other than the state of West Virginia, who has a chaotic situation with firemen's compensation at the moment, everybody else seems to be fairly well satisfied, and there are people still writing policies, even in other states where cancer presumption's been in effect for a long time.
Mm-hmm. All right. Well, thank you for your service.
Thanks.
Anyone else? We're all spread out in the room. That sounds like everybody.
Okay. Thanks.
Enjoy your retirement.
I will.
Before then. Okay. Our next panel is Mr. Elam Herr, Assistant Executive Director for the Government Affairs for the Pennsylvania State Association of Township Supervisors. Elam, it's great to have you here.
Thank you, Mr. Chairman. Good morning.
Morning.
I am Elam Herr. I'm the Assistant Executive Director for the Township Supervisors Association. You have my testimony, so I won't read it to you this morning. But I do want to make a couple comments and open up myself to some questions. First of all, townships comprise about 95% of the land mass in Pennsylvania and over 5 million, over 5 million of the population. So the volunteer fire departments are very critical to my membership. Without these volunteers doing the duties that they do, whether it's actually responding to a fire call or going out to take care of hazardous material cleanup or whatever, they're very vital to us. The cost to replace the volunteers. It's been estimated by fire commissioners in the past to be $8 to $10 billion annually to the citizens of Pennsylvania. A substantial cost to the taxpayer, would be a substantial cost to the taxpayers. So this issue that's before us today is one of the issues that needs to be addressed if we are to keep the volunteers as a viable entity. And remember that the volunteer fire companies started within this state many eons ago. Host municipalities are responsible for the premium dollars for workers' compensation under the Workers' Comp Act. So whether it's the fire company that's actually paying the premium dollars or the municipality directly, it is coming from, most of it is coming from taxpayer dollars. And the problem has grown in the past since Act 46 of 2011. We're not saying that Act 46 shouldn't have been passed. What we're saying is that has created a widespread fiscal impact that the insurance industry was not prepared for back in 2011. At that time, the data was not there of what the cost potentially would be, but if you looked at other states that had similar language to what was to become Act 46, you would see that the data did not show that the liability could be there. The problem was with Act 46 that it had a 600-week look-back period, but no reserve money for that. So, you know, being practical and fiscally conservative, everybody should get scared when you have a potential liability of 600 weeks ago and nothing there to cover that cost. So at the end, what happened in 2012, the majority of private insurance companies got out of the business of providing workers' compensation, and the result was that SWIFT literally got stuck with the fire workers' comp for volunteer firemen. And as you heard earlier this morning, that created a substantial problem for SWIFT. As we stated in previous hearings, the financial burden on local government is substantial. So we have worked with Representative Ferry over the years since Act 46 to look at how we could lower the cost both to the municipalities and the volunteer firemen. The legislation that is before you today, 2522, which I realistically understand that it won't go anywhere since we're at the end of the session, but needs to be further reviewed for future sessions so something will come about. What it does is create authority for the Department of Labor and Industry to come up with regulations to allow municipalities to insure or create funds or pools to help cover the cost of workers' compensation. The critical provision in this legislation is that should a group of municipalities create a fund or pool, that reserve money that has been collected over the past 6 years and has not been used would come along with the workers' comp to the municipality or to that pool to provide the coverage. If you don't do something like that, we're creating another 2011, another Act 46, because no pool, no fund would come into it without any reserves for a potential cancer presumption claim. If, as the legislation also addresses, if the entire workers' comp liability is coming back or the exposure, potential exposure, then all the reserves have to come back with that. Because again, as you heard from a previous testifier, that the SWIFT has paid out claims. I am not sure because I have not seen the reports, but to date I do not think any claims have been paid out to volunteer firemen for cancer presumption, or if it is, it's been only a couple. But other claims for workers' comps have been paid. So what we're saying is that we ask that the committee continue to work on this proposal so that we can provide viable protection to not only the active firemen, but as stated earlier, to also those individuals that provide services to the volunteer fire company. I testified within the last 2 weeks on another bill dealing with the other types of volunteers, the volunteers that go out for traffic control, the volunteers that do paperwork, financial issues back at the firehouse, the people who actually go out and do the fundraising, need protection while they're doing those duties. Again, without those people, the volunteer fire company does not exist. With that, Mr. Chairman, as I said, you've had my testimony. You know I'm around to be able to answer questions, but I'll take any questions now.
Thank you. Members on the committee. Oh, we've been joined by Representative Boback. Thank you for getting here. Please. Question. You're basically in your testimony, you say that after the passage of Act 46 that this occurred, that they were moved out of the trust to to SWIFT. The Insurance Federation says that Rep. Ferry is right, only a few private insurers remain in the market. That did not happen because of Act 46, though it happened before then as municipalities formed trust as an alternative to private insurers.
I semi-disagree with the Insurance Federation. Yes, trusts were formed prior to, and you will hear from members of a trust that's out there. Excuse me. But the biggest loss came when Act 46 came about. We not only were the trust providing workers' comp protection for volunteer firemen, but you also had individual insurance companies. Actually, right now, there's 1 or 2 insurance companies in the state that are still providing some workers' comp.
Right.
But Act 46, although all the benefits that are in that act, still had that questionable 600 weeks look back without reserves.
Thank you. Any members' questions? Yes. Representative Barbin.
Thank you, Mr. Chairman. Thank you for testifying. I'm just wondering on this 600-week look back, is there anything that you can see in the law that would preclude a new fund from being established that didn't have a 600-week look back? Because to me, that would have to lower the overall risk of the premiums. What we were told in the prior hearings was that since we couldn't calculate what the potential loss was for those 600 weeks, they had to assume a very high risk premium. And to me, that sounds a whole lot like factoring in, a war premium. If you're going to go to war, insurance costs more money. But since that didn't really occur, could we establish a fund, a self-fund for municipalities that wouldn't have a look back in it, and wouldn't that be less expensive?
The way the law is written, you'd still have to have the look back. Could you establish a fund, a trust, without the reserves for it? Yeah, I think you could, but I don't think any financial advisor or any insurance company would tell you to do that. Even when we were working on what became Act 46, we looked at other states in the country and looked at their experience ratings for volunteers. Yes, there were some claims, but in Pennsylvania there was no data on what potentially would be the cancer presumption. I would personally think that today, with air packs and everything, that the exposure would be less than it was 10, 20 years ago. And hopefully with the other equipment that is provided or can be provided to the fire companies would also lower exposure ratings. But again, if you think about it, when a fireman goes into a building and he has an air pack on, he's not breathing the smoke. But a fire police person who's directing traffic may be downwind from that fire, and he doesn't have an air pack on. So, you know, to sit here and say you could do it without potential liability and exposure, I just think it would be tough.
I think what I'm taking from this is you have to have the reserves, but you could establish a different look-back period for a self-funded trust or a state-related trust for municipalities, and that cost would be lower because that's what we found out over the last 7 years. We've had 350-some weeks to look at this, and all we know is we don't have that claim structure that we were told we would have.
That's correct. But again, the legislature would have to change the law from the 600 weeks to whatever. I'm not sitting here today to say that that should be done. You know, there would have to be other research done to see whether that is truly viable or not. Again, we do not want to promote, do anything that would also turn people away from wanting to be a volunteer in their community.
Thank you. Anyone else with questions?
Just one clarifying.
Representative Ferry.
Just actually two clarifying points. One, fire police actually aren't eligible for cancer presumption. They have to be a firefighter under statute. I just want that to be clear. I'm not saying you were saying that they were covered. I just want that to be
No, but I was
clear to the
just
members.
showing about the different types of exposures that are out there.
And with the 600 weeks, it's been talked about a couple times here. 300 weeks comes with the presumption. The second 300 weeks, the burden is on the claimant. So it's important to denote that as we've been over 300 weeks since the law has been enacted, I'm sure anybody that was diagnosed in that window of time would have filed under their first 300 weeks. So the statute with the presumption is actually tolling on individuals as every day goes by as they're diagnosed. So the second 300 weeks, the burden is on the claimant. They don't have the benefit of that presumption. That's an important component that was negotiated into the bill.
This is true, but it's still, you know, there is that exposure over that time period. It's just not the presumption as you stated.
Any other questions from anyone? Hearing none.
Thank you.
Elam, thank you for your testimony today. Okay, our next panel consists of Mr. Jeffrey Beauchamp, Esquire and General Counsel, and Mr. Robert Solars, Executive Director, and Mr. Frederick Schultz, Chairman of the Insurance Buyers Council, representing the Delaware Valley Municipal Management Association and the Delaware Valley Workers' Compensation Trust. Gentlemen, it's a pleasure to have you here again. Always good to see you. And you can begin your testimony when ready.
Sure. Good morning. Good morning, Chairman Barrar, Representative Ferry, and committee members. My name is Robert Solars. I'm the Executive Director of the Delaware Valley Municipal Management Association and also the Administrator of the Delaware Valley Workers' Compensation Trust. I'm also here with us today, as you mentioned earlier, the Trust General Counsel, immediately to my right, Mr. Jeff Beauchamp, and also the Trust Underwriter, Mr. Rick Schultz of Insurance Buyers Council. We thank the committee for the opportunity to be before you this morning. For background, the Delaware Valley's Workers' Compensation Trust is a public employer group fund that provides coverage for 89 townships, boroughs, and authorities in southeastern and central Pennsylvania. We've been in continuous operation for over 26 years. We'd like to comment on House Bill 2522 by first stating that the Trust welcomes the spirit and intent of Representative Ferry's bill to develop a much-needed solution to the workers' compensation coverage issue currently impacting our volunteer fire companies. We also understand and respect the very important role of community-based fire companies in protecting the lives and property of the Commonwealth citizenry. Further, the Trust and its municipal members are very willing to work with you to develop a sustainable benefits model for our volunteer firefighters. As such, we welcome participation in this process to achieve this proposed legislation. Now, to that end, and to develop a sustainable workers' compensation benefits model, we see the need to address some important threshold issues. Starting with a fundamental premise of House Bill 22 is the assumed availability of excess reserves to fund the startup and sustainable operations of the proposed group funds. Just to be clear, we understand the term excess reserves to be the funds estimated and set aside by the State Workers Insurance Fund to settle all accepted claims and future unknown but expected claims. So therefore, due diligence must be completed to actually determine the available amount of any such excess funds. That due diligence would include, but not be limited to, an independent claims and actuarial audit of SWIFT's volunteer fire company claims data. That needs to be completed to determine the amount of any excess reserves or funds reserved by SWIFT to settle the subject claims. We would need SWIFT to provide a complete database of all relevant claims data. Next, we would also need to do, or there would need to be done, an underwriting analysis. That would need to be completed to determine the necessary capital and reserve requirements to ensure that any group fund will be sustainable at reasonable rate levels. This will again require a complete and verifiable claims database and the dedicated staff resources of SWIFT. We would need to cooperate, either we or anybody else would need to work with SWIFT. And next, also, the Commonwealth must provide a financial backstop for deficits in any volunteer fire group funds to prevent group fund insolvency and to avoid any ruinous assessments. Once set up and to remain solvent and sustainable, these new group funds would require professional administration as well as Pennsylvania Department of Labor and Industry approval and ongoing regulatory oversight. The funds must be responsibly underwritten, sufficiently capitalized, and carefully administered in accordance with L&I and insurance industry standards of practice. For example, some, not all, but some fire companies have high experience modification factors, what we call MODs, whereby claim costs consistently exceed paying premiums. It is therefore imperative that any group fund have the discretion to adopt appropriate underwriting criteria so that the minority of companies with consistently high MOD factors would be ineligible to participate in a group of better managed companies. Now, aside from the financial issues, and we just touched on this recently, another very important threshold issue is the outcome of the two pending Act 46 case decisions, and specifically the legal and financial uncertainties surrounding those and the cancer causation presumption resulting from the Act. The outcome of those two court cases will have a very significant impact on the feasibility and sustainability of the proposed group funds. And for the record, those two cases are Sladek versus the Workers' Compensation Adjustment Board or the Philadelphia Fire Department, which is now before the Pennsylvania Supreme Court, and Bristol Borough versus Burnett, which is before the Pennsylvania Commonwealth Court. Now, we recognize the committee's hearing schedule, so we have provided our testimony in writing that supplements my comments just made, and also the submission of some suggested Act 46 related provisions. We are respectfully submitting these, and they are intended to assure the success and sustainability of the proposed group funds. I'd now like to ask our General Counsel, Mr. Jeff Beecham, to address the relevant legal issues, aspects of Act 46 cases and their potential to impact these group funds. Jeff?
I'd like to answer Representative Barrar, Representative Barbin's question about the 600 weeks. That can only be changed via legislation because all the coverages that we provide must comply with the statutory requirements in the Workers' Compensation Act. So 600-week period, look-back period, cannot be reduced or altered for a particular group fund. And that obviously is perfectly feasible via legislative action, but it can't be done unilaterally, certainly by regulation. You can create standalone volunteer firefighter group funds. The group funds are permitted under the regulations and the self-insurance provisions of the Workers' Compensation Act. Obviously, they have to be well capitalized. Colorado, by the way, to answer another question I think Representative Ferry had about what other states have done. I believe Colorado has adopted sort of a hybrid public funding mechanism for their cancer presumption law. I believe it may only apply to paid firefighters. Different states obviously rely upon volunteer fire companies to lesser or greater extent. But there has been, in some states, some public finance options adopted to address the as yet undetermined risk associated with cancer presumption laws. We have in the past, before this committee, very candidly and somewhat consistently noted the importance of the case law. It has taken 7 years since the enactment of this law for key issues to come before the Pennsylvania Supreme and Commonwealth courts, the most important of which Bob has mentioned, the Sladek case. Sladek involves some fundamental issues as to what is the burden of proof required of a claimant before the presumption applies. And one of the I'll put it to you very simply, it is our position under Act 46 that a claimant must present competent expert testimony establishing a prima facie causal connection, general causation as we call it, between the firefighter's carcinogenic exposure, that is the type of carcinogen, and the cancer that the firefighter has suffered. This case is very important because it will determine the burden of proof that a claimant must present, and that will materially impact the underwriting. If the case goes against us and the Commonwealth Court's very well-reasoned opinion is rejected, then we may have that may be a major setback from an underwriting standpoint. Secondly, the Burnett case mentioned by Mr. Solars involves a challenge to the PENFERS requirement. If you recall, the PENFERS requirement is basically essentially that volunteer firefighters, volunteer fire companies, document the carcinogenic or toxic exposures in the PENFERS system. That is important for volunteers because obviously they have workplace exposures that may very well be and often are completely unrelated to firefighting. The PENFERS requirement is a critical bulwark of the statute. And if in fact there are, and frankly I'll candidly acknowledge, if there are administrative issues with the PENFERS system, they can be addressed. But the statutory requirement must stand as is and fully enforced. In this particular case, there was some testimony presented that the PENFERS requirement could not be satisfied. It was sort of an impossible burden. But that we don't believe is legally sufficient to write it out of the statute. Rather, what we would like to do is constructively engage the department and the volunteer fire companies and I think the Pennsylvania Fire Commissioner in helping to fashion a PENFERS system that will address the core concerns created by this statute as it relates to documenting carcinogenic exposures. There are some, as Mr. Solars mentioned, some tweaks, if you want to call them that, to Act 46 that we would like ultimately to be considered, at least as respects to the volunteers. And that's simply because they obviously are full-time employees, presumably. They have jobs. They generously volunteer their time. One of the big components of any Act 46 claim would be the medical expenses, as you can well imagine. So one of the suggestions that we made back in 2013 before this committee was that medical insurance or health insurance be primary, and that the coverage provided by the trust and other workers' comp carriers under Act 46 for volunteer firefighters be excess for medical expenses, the medical expense component of those claims. That would materially lessen and indeed make more manageable the significant health care cost risk associated with cancer presumption claims, and also can be justified by the fact that many volunteers do have medical insurance. Certainly with the Affordable Care Act, they're probably covered, either their employer's coverage or otherwise, Medicare or whatever, such that that would not unduly burden volunteer firefighters or volunteer fire companies. And it may actually make this act, frankly, or these claims more insurable. That's one of the tweaks or improvements or modifications, whatever you want to call it, to Act 46, that we would ask you to consider as it relates to the volunteer firefighters alone, not the paid firefighters. Other states have essentially either have a reduced look-back period for volunteers or carved out only certain cancers. Obviously, once you get down that road, it's extremely difficult, frankly, to isolate causes of various cancers. Most of the cancer claims that have arisen under Act 46, and admittedly the vast majority of which have been paid firefighters, have concerned prostate cancer. And prostate cancer, hotly debated, but it's fair to say that the weight of medical authority is that prostate cancer bears little or no relationship to firefighting or any carcinogenic exposures that would be rationally or logically connected to firefighting. So we stand ready to work with the Department of Labor and Industry in obtaining the necessary underwriting claims data to see what the capitalization costs for these standalone volunteer firefighter group funds would be, work with the committee in fashioning some legislative remedies that would ensure meaningful volunteer firefighter coverage under the Act that would be sustainable. And that's very important because L&I doesn't care if you charge lots of money for any workers' comp insurance. Their concern is the other end, is that the rates would be insufficient to pay the claims. So we must work constructively with them to fashion a model that is feasible. And I think this is a great idea. We certainly endorse it.
Great.
That's our presentation.
Thank you. Representative Ferry.
Thank you, and thank you for being here, gentlemen. For the committee's knowledge, in my previous life working in municipal government, our municipality was insured by their workers' comp trust, and that's actually where I, in part, developed some of the ideas and concepts that are before you today. You know, one of the things I found, and Rob, you can jump in, one of the things I found very palatable was the process of claims and also the extra benefits. They had workman's comp safety grants. So, for example, I could get a generator for our public works building through their grant program, and that would actually potentially reduce claims, because if a storm came through, power was out, and the public works crew was called in to clear trees off the roadway, but if they didn't have power to their building, they're walking in the dark, potentially tripping and injuring themselves. We could buy chaps for the chainsaw crews to protect them. And I found that very palatable in an ideal world, and I know we don't live in one at home, nor we certainly here. You know, my thought was that, you know, we could really develop great models through numerous trusts that actually would reduce claims, reduce exposures, and ultimately benefit the health and welfare of the first responders through joint training, potentially joint purchasing of safety of equipment and all. But before we can ever get to that day, we need to find a way to be able to have these trusts developed. Just a couple quick questions for you. We're calling it excess reserves, and I read through some of the other testimony of some folks that won't be testifying here today, but the way I envisioned that was fire departments paid $200,000 in premiums to SWIFT over, say, 5 years. I'm just using easy math. They had $30,000 in claims of medical and lost wages, so there's a balance of 170. SWIFT, obviously, we would have an administrative fee they could take off the top for their aggravation in dealing with this whole process, and then the balance of that, or some high percentage of that balance, would be what would be portable. And then that would be the capitalization, I think, as you said earlier. Without some money coming with these fire companies, would there be any way to form these trusts?
I think the simple answer is
oh, sorry, Rick, you can, yeah, sorry.
The simple answer is, without the capitalization, there's just too much risk to start up, because whoever becomes a member of that trust has joint and several liabilities. So you're taking on that exposure without any idea of without having enough cash to at least start.
Right, because you're not starting with reserves. You're not.
Right.
You need to start up cost covered, and that was where the concept of making that money portable for that department comes. To touch on another one of your points, I wasn't thinking that you would have departments imposed upon you. I was thinking like your current model, where your board is made up of members or of representatives of the members. And if Langhorne Middletown Fire Company wanted to join your trust, the members would vote. You would obviously have our lost history, and you would look at it. And if you felt they weren't a good fit or could turn your trust upside down, you have the ability to say, no thanks. Correct. That's right. How you operate now, correct?
Yes. That's correct.
All right. Jeff, do you know roughly a time frame for some of these court decisions?
I wish
ballpark?
I did.
I mean, do you have a ballpark idea? Have they had arguments yet? Have they?
I think the baby is overdue for the slated case.
Okay.
By at least a month or so. Oral argument was 13 months ago. We fully expect that a decision could come down any day now. But that, I was saying that a month ago. We don't know. But I attended the oral argument September of last year. It's a complicated issue. It's the first time the statute's really been construed at the highest level of a court system, so they're taking their time. But I fully expect a decision by the end of the year.
Okay. And two clarifying questions on each of the two cases. With the Slated case, you said it's your stance that competent expert testimony be provided to get the presumption. So if somebody's filing under your model, if somebody's filing a cancer claim, like let's say I wanted to file one right now, what would I have to provide under that? I mean, is my doctor diagnosing me and saying,
well, you'd have to be diagnosed with a cancer. There would have to be some expert testimony establishing a general causal relationship between the carcinogenic exposure that you claim caused your cancer and the cancer that you have. That is typically, that has been provided, by the way, in all the claimants' cases that have thus far been litigated. So we're not asking claimants to do anything that they haven't been doing already. Once that general causation testimony has been introduced and deemed admissible and competent, then and only then would the presumption, assuming all the other conditions in the statute are met, would the presumption arise. And that presumption can be rebutted by substantial competent medical expert testimony establishing that indeed the expert's contention on the claimant's side is speculative and unfounded and isn't supported by generally accepted scientific principles. Because there's a lot of, shall we say, voodoo in cancer causation testimony, given the long list of carcinogens identified as a group 1 carcinogen. Sunlight is a carcinogen if you accept a certain degree of exposures. So you can't really divorce the exposure from the causation. You can't carve that out of causation. But that analysis, the burden on that is essentially on the employer in rebutting the presumption. So the Slated Court's going to address, the Supreme Court's going to address in Slated both what it takes to make a prima facie case triggering the presumption as far as medical causation testimony is concerned, and then what kind of evidence would be necessary to rebut that presumption. And that is the game. That is the entire game at that point. And if it's simply that I've got cancer and I'm exposed to a carcinogen, cancer A, and I've got a dozen or 102 carcinogens, pick a carcinogen and whatever cancer I have, I'm off to the races as a presumption. That could be a very big problem from an underwriting and legal standpoint.
And obviously you guys aren't providing insurance right now for volunteer companies, so I just want everybody to understand that. You're just giving your opinion on what you think the process should be based on that current court case.
Well, actually,
and the statute.
that court case, it's a matter of statutory interpretation, and we were very much involved in its passage, and we know exactly what we thought the key terminology in that statute meant, and we're hoping the Supreme Court of Pennsylvania will agree with the Commonwealth Court, who, by the way, exhaustively examined the statute and construed it in the manner of which I just described.
Okay. And when you say provide testimony, that's because the claims are denied? So it's not part of the initial claim submission. It's because the claim was denied. Were you saying testimony?
No, I'm saying that in the claims process, these are fully litigated or adjudicated claims. These are not thrown out. Essentially, they went before a workers' compensation judge in Slatic, and I forget the cancer in that case. There was a finding that indeed the cancer was compensable. The Commonwealth Court reversed the workers' compensation judge, issuing an opinion essentially saying the workers' compensation judge applied incorrect evidentiary standard, misconstrued the statute. And now the Pennsylvania Supreme Court has taken up the appeal from that Commonwealth Court decision and is addressing that. What I'm proposing is nothing more than statutory interpretation, what we believe the statute, how it should be interpreted, how it was worded.
Okay, and just one quick question on the Burdick case. What is it because I mean, we should absolutely be working with the State Fire Commissioner on this to get that part vetted within PENFERS. What is it in terms of the documenting the exposure do you think should be on the PENFERS report?
Well, I think there's enough there, frankly, to document carcinogenic exposures in the PENFERS reports as we've seen them. In this particular case, there was a contention by former Fire Commissioner Mann that the PennFERS requirement could not be met by volunteer fire companies because of some inadequacies in the formatting or the software. But what we have seen and what we reviewed before the statute was passed contradicts that. Essentially, that there is a narrative, if you will, part of the PennFERS report that can be used to document unique carcinogenic or hazardous exposures. And as you well know, volunteer fire companies in the state don't fight that many structural fires, and certainly of those, it's a relatively small percentage that involve commercial structures where hazardous or toxic substances would be, like a chemical plant or something like that, would occur. So the system, I believe, is sufficient the way it's formatted, and it may just be a matter of educating the volunteer fire companies, providing some limited degree of subsidies if there's a cost associated with it. I had thought there were some grants that volunteer fire companies could get so they could get the PennFERS system. Probably 40% don't have it yet.
The PennFERS system has actually been provided to every company. It's whether they chose to use it.
Right.
And when they started to use it. Our current fire commissioner, actually, Fire Commissioner Salve, actually, with our state fire grant program, it requires you to PennFERS report as part of the incentive to use PennFERS. They actually, for the first time, started not awarding grants in this past cycle for those that aren't using PennFERS. Wow. So I think you're going to see a much higher group using PennFERS. The problem is, for those that haven't been using it, if somebody turns around and has a cancer claim tomorrow and they just started using it the past year, they may not have the documentation they need. But
exactly.
Okay. Thank you.
Yeah, but the follow-up on your concern with the PennFERS is last year when Commissioner Salve did that, we had quite a few members were not happy with his decision to go there. Your testimony outlines the importance of making sure that this is done. So thank you. It gives us a something we can hit them back with and say, look, we need these reports done. If you truly want to protect these firefighters, we need these done.
Well, you do need to isolate and document the carcinogenic exposures for volunteers that are unique to their firefighting activities and not their otherwise common workplace exposures, because you're dealing with volunteers.
Right. Any other questions from members? Gentlemen, thank you for your testimony, taking time out for us today.
Thank you.
Let's see our next panel. I turned it off. Our next panel consists of Ms. Amy Sturgis, Director of Government Affairs, and Mr. R. Scott Argall, Principal Consultant for the Insurance Buyers Council, representing the Pennsylvania League of Pennsylvania Municipal League. Thank you.
Thank you. Good morning. I'm Amy Sturgis. I'm the Director of Governmental Affairs for the Pennsylvania Municipal League. With me today is Scott Agar, Principal Consultant with Insurance Buyers Council. Scott's firm provides consulting and actuarial services to Penn Prime, a municipal insurance service of the Pennsylvania Municipal League. Penn Prime offers property, liability, and workers' compensation coverage to municipal entities. It is a trust owned and operated by its members. In 2013, Penn Prime was forced, along with other trusts, to leave the volunteer firefighters workers' compensation market because of the significant risk exposure created by Act 46. I want to thank you for the opportunity to provide comments today. We all agree that volunteer firefighters provide a valued and needed service throughout Pennsylvania. They deserve insurance coverage and efficient administration of their claims. As we understand it, the goal of House Bill 2522 is to provide the tools necessary to reopen the municipal trust market for volunteer firefighter workers' compensation so that municipalities have affordable options when purchasing coverage. We wish to be part of the solution. Penn Prime is interested in being able to offer this coverage again. Returning to the market, however, will be a decision based upon the actuarial soundness of any legislation enacted to achieve that end. From our standpoint, the first hurdle in forming a new mechanism to finance volunteer firefighter claims is to determine an appropriate funding source. It is necessary to ensure obligations can be met while maintaining both stability and viability. House Bill 2522 identifies excess reserves maintained by SWIFT as the funding source. We've had a little bit of an explanation this morning about exactly what that means, but we still need to have more clarification as we talk about this issue, hopefully in months to come, about exactly how that would happen. A second and equally important consideration is determining how to secure excess insurance for claims above the primary insurance limits for both individual claims and claims in the aggregate. If excess insurance is not available for purchase in the commercial insurance market, alternatives will be needed in order to provide this necessary safety net for the financial stability of the trusts. A third consideration is providing a level playing field among public self-insured entities and group self-insureds offering the same coverage. Public self-insured entities are not held to the same standard in terms of required level of funding as group self-insured. Permitting the same level of funding for both types of providers removes a current financial disadvantage experienced by group self-insured trusts. Finally, consideration should be given to reducing the exposure caused by Act 46. Addressing some of the risk factors that drove up premiums would go a long way toward reducing potential costs and improving the likelihood that group self-insured trusts would be comfortable re-entering the marketplace. There are many challenges to providing affordable workers' compensation coverage to volunteer firefighters. The League and Penn Prime thank you for the opportunity to provide our initial thoughts on the legislation and the challenges of bringing the self-insured trust back into the market. We stand ready to provide further input as this concept develops. Ultimately, we seek actuarially sound solutions that promote trust viability while benefiting municipalities and their firefighters. Again, thank you for the invitation to testify, and we're happy to answer your questions.
Thank you.
Yep.
Questions? Frank Ferry.
Sure. Well, thank you for being here. One quick question for you, and it's actually something I meant to ask the previous panel as well, to take advantage of your insurance knowledge. You mentioned excess coverage. Rob mentioned a backstop. I assume you're talking about the same thing. Since I don't know we could rely on the private market to be providing excess coverage in this, would you be looking for some sort of perhaps state catastrophic fund that picks up any claims over, say, $250,000 or over $500,000? Is that the kind of things you guys are referring to?
That certainly is one of the options that I think, would need to be explored.
Okay.
I hear you're thinking, you have ideas on how to do this, right?
Sure.
Thank you. Thank you. Any other questions from members? Anyone? Thank you for your testimony today. Greatly appreciate it.
Thank you.
I think that's it, right? Okay. Representative Ferry.
If all the stakeholders or anybody that's here today or not here today has any thoughts or comments, because obviously this bill's not going to move this session, but I'd like for us to continue working on it. Hopefully we're all still here come January, but it's obviously there's a foundation here we can hopefully build from. So we do have your comments here, but the actual minutia of what's going to be in language and whatnot, I would like to kind of continue working with the stakeholders on that. So if you have any thoughts or comments, they can get them to us. I'll be following up with the department to clarify some of the things you have. I'll be following up with insurance as well to clarify some of their comments. Because the Insurance Federation, Susquehanna Trust, and the Department of Insurance also submitted written testimony, just so everybody's aware. We can get you copies of that if you're interested. But I think we would need to work out some of the technical, legal, insurance end stuff. And then for those that may be providers in the future, the practical end stuff for you guys as well. So, but thank you for being here.
Thank you. Yes, thank you to the panelists that took part today. We greatly appreciate it, and this hearing stands adjourned. Thank you.